Like, yeah, and then I'm like, okay, well, right now. No, I'm from the cars.
I mean, I think I would put it through when they're doing that.
Yes.
You know,
I love how.
yeah. Which one? Okay, so it's just. Yeah. Yeah, command.
Oh, sure. I'm not doing that. It's very good. Yeah.
Yeah, they've got to be like something. Yeah. And we got. Josh and one of my old. Yeah. Actually, my hair on here is touching. Yeah.
I just wanted to let everybody know we're gonna have a little bit of a delay in starting. One of the lawyers, had to run back to his office and pick up the papers, that he's going to use to argue the case to us. So I just wanted to let you know, we're not the one that's late. We're not the one that's behind all of them. So we'll get started just as soon as he gets here.
But that should. Yeah. Yeah.
Sherry Williamson. That's the AG. Appreciate you coming out for us. Yeah.
We got it pretty well. It's not. Okay. You're the creative name. I got.
Where you at? You're not. Oh, wow. Oh, wow. Yeah. Hi, Sherry Williams. Yeah.
How you doing, sir?
Do you make it? All right, now you'll have 3 minutes at the beginning to speak to the students.
Okay.
About your case.
Well, I'm gonna say,
Okay, do you need to have a minute before I go tell the judges?
fine.
You're ready? Okay, I'll go get them.
Give you the name. Sure. He just got me. He's like, he's willing. He's got his experience. I'm 65. He had 70. It's over. 2 years, 2 months. Sorry for you. Well, congratulations first.
Yeah, they.
Well, something that's things not out there. That's great.
your house. Yeah.
See this through, man, see it through. Oh, so you're gonna work.
Well, like, I'm
Think it is expensive. Maybe you might get a pepper.
All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and God save this honorable court.
You may be seated. I want to welcome everyone to the afternoon session of the McLennan, of the court holding, oral arguments at the McLennan Community College. It's an honor to be here. It is something that we tried to do, the legislature about 2 decades ago. When Rex Davis was chief of the court, the legislature passed a bill that said we could hold court other than in our courtroom. For the most part, that has meant that we travel out of town. We go to Sam Houston State University in the fall of each year, in the spring of each year. We go to Glenn down in Bryan College Station in the fall of each year. And President McCowan was at a meeting a little over a year ago with Steve Smith, justice on the court, and they got to visiting. And President McCowan determined that, hey, it would be a good idea if the 10th court would come to my campus, meaning her campus, of course. And so she invited Steve, and Steve presented the idea to the court. And with that, here we are on Constitution Day in 2024, and it's truly a privilege. Dr. McCown, I yield to you, and I don't know if it should be doctor or president or the Queen. I don't know exactly how to refer to you, but I yield the mic and the audience to you.
Chair. Get into ship is fine.
This has been such a great honor for us on Constitution Day. Our faculty make this happen with Lindsay, of course, and our students are so appreciative. So I thought I would let one of the students say thank you.
I just wanted to say thank you on behalf of all the students at MCC and all the faculty. We really appreciate you guys coming out here. So thank you very much.
Thank you very much. At this time, I want to remind everyone to turn off their electronic devices, or at least put them on silent. I used to specifically mention pagers, but Rex pointed out to me that that somewhat dated me. And so I'll now just say electronic devices. We do allow movement if you need to leave for whatever reason during the course of the arguments, you can certainly do so. I refer to that as movement with manners. Remember, this is a real case. Someone's liberty interest is at issue as a result of what we decide today. So be respectful as you move around the room. There are a few differences between holding oral argument in this environment versus up at our courtroom in the McClellan County Courthouse. We've got a situation where if you want to take a photo to commemorate today, Constitution Day 2024, you are free to do that. We allow the parties, and this is kind of where you really understand what we're doing here. This is an educational opportunity for you all as well as us. We need to be educated on the law, and the parties are going to argue their legal positions to us. But we also want this to be meaningful to you, and we recognize that there is a gap between your legal knowledge and our legal knowledge. And so we have asked each of the attorneys to turn to you at the first 3 minutes of their arguments and put the case in context, either factually or legally, so that you can then understand what they are about to argue to us. We don't take that time away from them. And we allocate 3 minutes for that, and then they get their full 17 minutes to make the arguments to us of legal or the legal arguments that they're going to make. We may have enough time. We took some time at the 12 o'clock hour after the second case this morning to do some Q&A. And if we have time and y'all have a burning question, we may be able to take that after the arguments this afternoon as well. So if you have something, write it down. And at this point, I will call the afternoon case, Holland versus the state of Texas. Announcements from council.
Stan Twigger for appellate, better late than never. But I am here and present for Mr. Johnson.
Thank you, council.
David Vernon for the state.
Thank you, Mr. Ryan. Have you got your heart rate back down from that rapid drive across town and so? All right, you've got 3 minutes. Let me get the program set up.
That mic is hot.
This mic. Thank you.
You may proceed when ready, council.
May it please the court, members of the state audience, and Judge Devin Yager. My name is Stan Schwigger. I'm here on behalf of the appellant in this matter. And what we are presenting today is 2 arguments concerning his conviction for the offense of continuous sexual abuse of a young child. We're going to get pretty technical in this, and what's going to happen is I'm going to argue concerning what is called propensity evidence. Propensity evidence meaning that basically that the state is allowed to introduce actions prior to the trial that shows that he acted in conformity with his beliefs. The legislature recently allowed that statute to allow propensity evidence in 2013. They amended that statute. And we're going to argue 2 points on that particular issue. First, the state has to prove beyond a reasonable doubt, according to the statute, prior to the testimony beginning, that the appellant had the propensity or the acts that he is accused of showing propensity. In this case, it was 2 acts that he was accused of as a juvenile, demonstrate his propensity to commit the offense of sexual assault or continuous sexual abuse of a young child. And so those actions were allowed into the trial under the statute showing propensity, but the statute, and here's where we're going to get a little lost on this. What we're looking at is the term separate offense. And the term separate offense in the statute allowing propensity evidence into the trial, I believe, does not include the term juvenile adjudications. The legislature would have specifically included that term in the statute had it intended to do so, and not saying those specific words. It is my argument that the juvenile adjudications were not encompassed by the term separate offense. There's also a rule of evidence called 403. 403 is kind of a catch-all saying it ain't fair. And so even if the evidence is allowed under the statute, 403 allows the trial court to weigh the prejudicial value against the need and other elements by the state. In this case, unadjudicated sexual offenses have always the potential, and I believe in this case, did tip the scale in the prejudicial weight of that evidence. And therefore, we will present both of those arguments before the court today.
Counsel, you have 17 minutes. You may proceed when ready.
Thank you. May it please the court. Prosecutor from the state, members of the gallery. I'm here on behalf of Mr. Brian Holland, and as I explained to the audience, it is my belief that appellant's juvenile adjudications were barred in the guilt phase of this trial by the plain meaning of the statute, and that juvenile adjudications were also barred by Rule 403. The statute in this case states that evidence that the defendant has committed a separate offense may be admitted in the trial to prove that he performed in conformity of his character of the defendant. The state claims in their brief that this separate offense is plain and requires no further construction to determine its meaning. It opens the umbrella, and however that umbrella is formed by two unpublished cases. And I would like to deal first with those unpublished elephants in the room. Those arise from Denzelbeck versus State, that is cited in the state's brief, Texarkana 2002, Perez versus State, which was the first case which was relied upon by Denzelbeck, a non-published case out of Fort Worth. Both of those courts found that if the legislature had intended Article 3837 to apply to only extraneous offenses committed by the defendant once they reached the age of majority, it would have said so. In the terms of the fictional Colonel Sherman T. Potter, horse hockey. First, both of the cases have no precedential value by rule under 47.7 of the Rules of Appellate Procedure. Reciting a memorandum opinion in a memorandum opinion provides no support for precedential value. Moreover, the Fort Worth court started and misstated their authority they relied upon. The authority they relied upon is Miles versus State, 506 Southwest 3rd, 485. The Court of Criminal Appeals said in that case, we assume the legislature means what it said and derived the statute's meaning from the words the legislature used. That's where the state stops. But contrary to this claim, the plain meaning is not determined solely by the words used. In fact, a reviewing court is not to lift out of context the language applicable from the statute and construe it standing alone to reach a desired result. That's exactly what the state did. That's from Brunsfield versus State, 813 Southwest 2nd, 158, the Dallas Court of Appeals opinion, which was affirmed later on by the Court of Criminal Appeals. In fact, there are several canons of statutory construction which support appellant's definition of a separate offense. A statute's plain meaning is typically understood by looking at it in the entirety of the statutory scheme and placing that particular provision, the separate offense, within the context of that statute. The Brunsfield Court of Criminal Appeals opinion, 843 Southwest 2nd, 521, says we presume that every word was used for a purpose. And also this court in McClendon, cited in my brief, presumes that the legislature intended the entire statutory scheme to be effective. This court in addition said the plain meaning requires that the meaning in effect is to be determined in connection to other statutes. So how do we put this together? By use of these canons, this court should find that a juvenile disposition or adjudication is not intended to be included as a separate offense. The terms separate offense have been legislatively defined. From the from the Code of Criminal Procedure and the Family Code, both have defined what that means, what separate offense means. The legislature is presumed to have knowledge of those terms, use them intentionally, and with knowledge of these technical meanings. I think looking back on the seminal case of Grunsfeld from 1992 provides further assistance. I think we were all around when that case came down, and that case dealt with the use of whether extraneous offenses were allowed in the punishment phase of a criminal trial. The legislature in the previous session had tried to overrule the prior opinion of the Court of Criminal Appeals, amending the sentencing statute. But they didn't touch the term that was necessary, prior criminal record. The court noted the legislature had not modified that and had not changed since 1967. And adhering to that decisions, the court held that the acts, the extraneous offenses in that case were inadmissible. Allowing introduction of juvenile adjudications under 3837 renders the express legislative designation of admissibility in adult case a nullity. We can also go down another route.
Before you go down the other route, let me pursue a greater understanding for me of separate offense. You've used that term. It comes from the statute. And you said it was legislatively defined or by case. Which one is it?
It is both. It is set forth in the Code of Criminal Procedure. I believe it's cited in my brief, and also in the Family Code, which defines a juvenile adjudication. It defines a juvenile criminal action as an adjudication, not an offense.
Okay. What I'm interested in, if you could address, are you talking about the introduction of the judgment of one or the other, a adult conviction or a juvenile adjudication as being the separate offense that is admissible in the adult context? Or are we talking about the underlying event, the facts? To me, there's a difference. And I don't know, I'm trying to parse your argument to understand what we're trying to.
In fact, I thought about that earlier myself. And in fact, I think it has to encompass both. That basically the facts, underlying facts of a juvenile adjudication as a separate offense, I believe the legislature would have basically designated the entire factual basis of a separate offense admissible as it would have on a juvenile adjudication. That's in fact what the state did in this case. They introduced both the document of the juvenile adjudication, in cross-examined the defendant with that, and also through two witnesses introduced the entirety of what was claimed to be the extraneous offenses concerning juvenile adjudication. So I think it's broad enough to encompass both.
Okay, and I need to address the question of preservation and objection. Were there separate objections made to the admission of the conduct that occurred while he was a juvenile, separate and apart from the physical piece of paper, if it was introduced, that was the juvenile adjudication?
I believe all of that was handled, I believe all of that was handled in the pretrial hearing for admission of both the details and the actual document itself. I believe that the pretrial, it would be apparent to the trial court that basically they were trying to cover both bases with that hearing.
Okay, and under 40, and I may have the wrong evidentiary rule, 404, or at least 404 or 403, one of them requires a proof beyond a reasonable doubt that the defendant had engaged in the conduct for it to be admissible. If all we were talking about in this case was juvenile conduct, would it have been admissible?
Under which rule?
Well, let's stick with the rule of evidence first.
Under 404?
Yes.
It would have had to have been filtered through 403, and I think either way, if you use 3837 or 404B, I believe this court in past cases held that that could be held, be used as a bad act
Okay,
instead of a laundry list of other things.
okay. What about under the statute?
3837? No, I don't believe that either of them are admissible for the purposes of, by using statutory construction. If the legislature had intended to use a juvenile adjudication, it would have said so. It is absolutely contrary to the announced rule in the two unpublished cases that says they would have used that term if they had intended to do so. That's not the way statutory construction works.
But if it would have been admissible, if it had not resulted in an adjudication, a juvenile adjudication, or at least made it to the 403 weighing analysis, why would the fact that there was an adjudication change whether or not the jury could consider it when he becomes an adult and they're trying to convict him of a new act?
It goes back to statutory construction again. If we're talking about a separate offense, acts committed as a juvenile are never considered to be an offense. If you're trying to admit it under a separate offense, then that requires a hearing and they have to prove that particular value. If you're trying to admit it under 403, which I do not believe the state offered it under that, and they would have their own error preservation issues at that point. But even if it was offered under that, it would have to be a bad act and they would have to, again, I think it goes to the propensity weighing at that point, and I think 403 kicks in and kicks it to the curb again.
Well, instead of the term separate offense, couldn't the legislature have made it abundantly clear and said separate conviction? That would clearly then exclude juvenile matters.
Right. But it also demonstrates that the legislature also understood at any point that a juvenile adjudication is a separate being from any offense. It is not considered to be an offense under the law. It is a civil matter.
See, but it's the conduct that conforms to a statutorily defined offense. And so, I understand the distinction you're trying to make, but it's actually the conduct. It doesn't delineate what age the conduct needs to occur at under 38 and 37. Isn't that something that could have been intended, just the conduct itself that conforms with an offense?
Well, we're prying into the collective legislative brain, and as I recall, the Supreme Court says you go there with trepidation. And yeah, they probably could have meant that, but that's not the way. I don't think that it's possible that we have that interpretation meet the standards of statutory construction. The legislature knows how to write a statute, supposedly, and they know how to state this conduct is going to be part of this particular instance. And so therefore, I believe that their failure to delineate that leads to the conclusion that it was not admissible under that statute.
And I want to see if I can understand the distinction that you want us to make. It seems to me that you're arguing a juvenile adjudication is not admissible. But yet a bad act performed by a juvenile would be subject to admissibility, potentially excluded under 403.
Well, I don't know that potentially even a bad act can prove propensity. I believe propensity reasons are excluded under 404B. You cannot show the character of the person, or you cannot show the character of the person through propensity evidence under 404B. Are we accurate on time here?
Yes.
Okay. I do want to touch upon the 403 exclusions and to determine admissibility in this case, a trial court must look at the probative value and counterbalance that with the cost of admission. The appellant's conviction is the poster child of the cost of admission. He suffered the right of his loss of a fair trial. The probative value in these cases is low. The Court of Criminal Appeals has already told us that the probative value is minimal when propensity to commit crimes is not a material fact in the case. So what we look at then is the victim's testimony, if it proved it at all, looking at the probative value. If that's accepted by the jury, the Ninth Circuit Court of Appeals said that proves all the elements of the offense. Proof of another act showing propensity contributes little to the case. The countervailing costs of introduction are substantial. Unfair prejudice, multiple dangers exist here. The Supreme Court in Old Chief versus United States at 519-172 states that the unfair prejudice speaks to the capacity of relevant evidence to lure the fact finder into declaring guilt based upon his propensities. Also, hostility and sympathy for one side without regard to the probative value of evidence is also unfairly prejudicial. Old Chief also instructs us that basically the risk that the jury will convict for other than those crimes charged or convicted because he just deserves punishment for what he apparently got away with earlier creates a prejudicial effect that outweighs ordinary relevance. Anytime that we have a child sexual assault, the Fourth Circuit says those allegations are more inflammatory and prejudicial other than any allegations that are seen in American courts. This weighs in finding of the error. There's also the potential that they misled the jury, that he's going to get convicted because he's a bad actor, that he avoided punishment for the extraneous offense and will engage in similar misconduct in the future. Let's examine what happened in this trial. What was the intent of the state? The state opened their arguments with propensity evidence. We're going to show that he had the propensity to do this. That's their opening statement. First two witnesses, propensity evidence. They didn't investigate. There were two investigators from the local sheriff's department. Neither of them participated in the investigation of this case. Both testified about appellant's propensity. There was nothing to offer as to the merits of the case from those two witnesses. The state merely dumped the gasoline can over on the already burning fire from their opening statements to paste this man a child predator. I can think of nothing more prejudicial than having that evidence in front of me as a juror before I've even heard a stitch of evidence concerning what happened in this matter.
Counsel, before you leave, let me ask any other question. You have a second issue in the case about the constitutionality of the statute. I know that we have addressed it before, but, I am. When you come up for rebuttal, I would like for you to at least think about a minute's worth of argument about that constitutionality question. Because, and I don't want you to go on it now because I'm kind of springing it on you and I know you didn't plan on arguing it, but if you get that to the CCA, I want to at least have had a chance to see what you're going to argue to them, if that makes any sense.
Yes.
See you in a minute. Counselor, you have 3 minutes to address the audience.
Fellow was indicted, tried, found guilty of 2 counts of continuous sexual abuse of a young child under 14 years of age. The young child was an 11-year-old boy. His initials were BD, again, name. He testified in guilt innocence due to the allegation. Also testifying in guilt innocence was a 13-year-old boy, initials ZR. He wasn't named in the indictment, but he testified to allegations of sexual abuse against the appellant as well. Continuous sexual abuse of a young child is one of several prerequisite sexual offenses alleged in, or they're listed in 3837 Code of Criminal Procedure. If you're indicted on one of these, state is allowed in guilt innocence to put in evidence that you committed other extraneous sexual offenses against victims not named in the indictment. And that's exactly what the state did. In the early 2000s, felon was charged by petition, which is what they call in the family code, with alleging that he engaged in delinquent conduct. The delinquent conduct was that he had sexually assaulted 2 boys who lived across the street from him, a 9-year-old Corey Anderson, and a 11-year-old, his 11-year-old brother, Colby Anderson. The appellant did not challenge this in a contested hearing. He opted to stipulate to the evidence. He was given probation in return in the order of deposition or disposition, which is that's called. At trial, the state offered stage 1, which is the stipulation of evidence, and stage 2, which is the order of disposition. They are both admitted over objection. The Anderson brothers also got to testify for the first time, because they did not testify in the juvenile matter. But they testified for the first time on what God did to them. The defense counsel objected under 51.13B of the family code and said you can't use the order of disposition, stipulation of evidence, or evidence adduced to juvenile hearing in the guilt innocence phase of a trial involving appellant when he's an adult, regardless what kind of offense this or trial was. It'd be just drug drops and use it in punishment, but not guilt innocence. The objection was overruled. Thus, appellant's objection was he got an adverse ruling, so it's reserved for appeal. He testified to the defense counsel then later in his case in chief, puts on an appellant. He asked him, what about the Anderson brothers' testimony? Is it true? Appellant said, yes, it is. Bringing up the issue of waiver. Another valid question is if the brothers didn't testify in the juvenile matter, does 5113B work to prohibit them from testifying in trial in the guilt innocence phase? Does it even apply to them? Does 3837 prevail over 5113B? And if it does, World War III balancing test, does the cognitive value, what is substantially weight by the danger of unfair prejudice?
Thank you, counsel. You may proceed when ready.
May it please the court, Counselor, audience. As just indicated, there seems to be an elephant in the room here, and that I agree there was a pretrial objection to this evidence. There was not, as I recall, a request for a running objection to it. When the evidence was presented, both the states 1 and states 2, as well as the Anderson brothers' testimony, defense counsel covered his bases and he objected again and referencing his pretrial objection to this. He's obligated, unless it's a continued objection, to object at each and every time that the same or similar evidence is offered in trial. He cannot introduce the evidence that he just objected to and preserve it for appeal. So there's definitely a valid argument that he waived this issue. Secondly, and I don't have any case law on this, I might admit, but if the plain language of 5113B says you're prohibited or prohibits evidence in a juvenile hearing being used in evidence of a later trial, well, if there's no evidence, it was a stipulation of evidence. The Anderson brothers were not there. They didn't testify. So how does 5113 act to prohibit them from testifying to something they never testified to before? It's not part of a juvenile proceeding. And if 5113B does not apply, then it renders harmless any error associated with the admission of the stipulation of evidence and the order of disposition. I think it's a valid question. As far as.
So are you making a distinction then between the acts that constituted the bad act and the piece of paper that was the adjudication from the juvenile proceeding?
Yes, I think, yes. Because the evidence adduced at a hearing is separate from what's specified in 5113B is they mention order of disposition can be used. They mention stipulation of evidence. And so I think all of them would be prohibited, but if all you got is two, you got the order of disposition and stipulation of evidence, those, if 5113B prevails over 3837, and that would have been error. But if the Anderson brothers didn't testify in any matter in the juvenile situation, then that would not be controlled by 5113B. They should be allowed to testify at trial the way he did to them.
And it's your position that the pretrial hearing on the admissibility of the juvenile conduct is not sufficient to preserve the objection to their trial testimony?
Can you run that at me again?
Is it your position that the pre-trial hearing to suppress the juvenile convictions, and I say the word convictions, juvenile adjudications, does not preserve the error or admissibility question of the testimony? In other words, it was the pretrial hearing on the suppression of the juvenile evidence sufficient to reach the disposition order, the stipulation of evidence, and the conduct that resulted in that juvenile adjudication?
If 5113B applied to them. But I'm just saying it doesn't apply to the testimony of the answer. Had they tested it, there's been a contested hearing back in 2005. Then yes, they would not have been able to test it. Well, actually, maybe they could. What if they testified to just what was in the stipulation of evidence? That stipulation and petition only named one act of oral sexual abuse against Corey and an act of sexual abuse against Colby and anal penetration. That was it. They testified it happened all the time, many times. each one of those is a separate offense, not included. And so, yeah, you could be able to, if they did testify and it was a contested hearing, you could say, okay, what you testified to on this one act, and this one act, and this one act, you can't bring that up in guilt and innocence. I think you could pair those off. But they never testified to all these others, so I think they should be able to testify in guilt and innocence to the other acts that he committed. Each one is a separate offense, separate count. And I don't think 5113B reaches those.
Okay, so if, we haven't read the testimony of what happened, what they testified to in this proceeding, but the document that is the juvenile adjudication and stipulation of evidence, if it was erroneously introduced in this case, where are we then with regard to preservation of error?
I think that with preservation of error, the fact that he brought in the substance of all of this by introducing and asking appellant, he heard their testimony, is it true? And he said, yes. Then all of their testimony comes in. I mean, the best case scenario for appellant is just harmless error. I mean, how can you say otherwise that you've got a stipulation of evidence, you got an order that just saying I'm putting you on probation? Not much prejudicial effect there when you got on the other side, most of these individuals who were the detectives with the sheriff's office. This is the first time they ever testified in public about this. I'm sure they were ashamed. But they get to tell their whole story, and if 5113B doesn't apply in that situation, then you've got all of this making much less prejudicial documents and the stipulation of evidence and the order of disposition. It would render it all harmless.
You don't think there's a difference between the introduction of a prior bad act versus an adjudication of guilt or a finding of having engaged in the prior conduct?
Well, actually, I'm not even sure it was, I mean, it's been a long time since I've done juvenile work. Is there such thing as an adjudication and all you do? I mean, all we know is he was put on probation. We don't know if he violated it or if there was a final adjudication. I don't think there was. But you just say, all you got is documentation that says, you're put on probation. And he says, yeah, I stipulate that I did this, what's in the petition. I think you can separate those things out if, well, not as far as waiver goes. I think if you would go in great detail of all of this, you've covered what's in the stipulation of evidence. It's also shown by the testimony. I don't think at that point, I mean, you've brought everything that's in the stipulation, you brought everything in that it's in the order of disposition, it's all the way. And as far as the one jumping to the weeds of the statutory construction, I know Delsbeck was an unpublished opinion, but that doesn't mean the reasoning is not sound. Often use unpublished opinions to hear what brilliance some of these judges have. I may not be able to cite it or I may cite it, I don't know. But the reasoning was they went through and they looked at the plain language to determine legislative intent. The plain language of 3837, and this is what they based, Delsbeck based its holding on, is that there's no language in here that limits extraneous sexual offense evidence to that which was committed by appellant only after he turned into an adult. So there's no limiting language on the 3837. And this amendment that would allow evidence such as the Anderson brothers to testify was 2013. The 5113B became effective September 1st in 1973. So 40 years that family code section's been out there. They're presumed to know existing law. And they could have excluded it if they wanted to. If they didn't, they could have limited no language. So just reading the plain language, it looks like this is wide open. You know, juvenile, doesn't make any difference. Comes in. In addition, rule of statutory construction is most recent, most specific prevails. Well, obviously, 3837, the 2013 amendment is most recent. But it leaves intact everything else, 5113B. It only carves out a special exception for special offenses, and sexual offenses are special. There is a difference in the mindset, there's a difference in the strength of addictiveness, as shown by the recidivism rate, by the extra protections we have put in place, such as registering as a sex offender for life, random polygraphs, see if you reoffended, third-degree felony, if you move more than 7 days beyond at another place, you got to register. This is because sex offenses are different. And as far as, you know, remoteness and character conformity, 3837 is the only statute that actually allows propensity evidence. They want to know what is his character, and how best to know that is, has he reoffended? Was it a juvenile? How long has he been doing this? What about his preference? In this case, Corey and Colby, 9 and 11. Then you got BD and ZR, 10 and 13. It's all in that age group. Same gender, same there. His MO is the same thing. It's favors, you let me do this. Favors taken away if you don't let me do this. Did it to all 4 of them. So that's highly probative that he has a problem. This is his character. This is what he does. I understand in other contexts, other offenses, yeah, it's too remote, it's too far afield. And you can't sit there and try to prove that he did this just because he wants to do that. But I think this is different. As far as the language goes, separate offense. The juvenile, I said I don't think there was an adjudication. It was a bad act, and all that state has to do is prove he got reasonable, he did it. But 5103 of the Family Code defines delinquent conduct, which is what you describe it in the Family Code, as conduct other than violating traffic offenses that violates penal codes of this state, the United States, and is punishable by imprisonment or jail time. Well, isn't that the definition of an offense? You're violating the law, penal laws of this state. So by definition, delinquent conduct is the same thing as a separate offense. And it doesn't have to be a final judgment, it doesn't have to be an adjudication. It's just the act. As far as the other factors of 403 analysis, there was an extraneous offense instruction in the jury charge, general and then specific to 3837, found in volume 7, page 31 to 33. So there shouldn't be a situation where the jury might have been misled or confused is what they were trying to decide. Yes, it was prejudicial, but isn't all evidence that established essential elements of the offense? Like, hell, it hurts, but what hurt me here, you know, with all your evidence? Well, you can't say it was unfairly prejudicial. And how much time was needed to develop this? I think their testimony total lasted about 11 pages with all the record. And none of it dealt with a needlessly cumulative of evidence dealing with the underlying offense with BD. So I don't think that, and also Rule 403 is the rule that favors admission of offense. You look at these factors, the term substantially outweighed undue or unfair prejudice. They could have used other words, and that's why case law holds that it is a rule that favors admission. So I don't think you have a rule 403 problem here. I think that 3837 prevails over 5113D. And frankly, I don't think we even get started or get out of the gates, because I think that by having appellant admit to all of this, he waived any issue that he had earlier preserved. As far as issue 2, the constitutionality, I have nothing else more to say than what Jason did in his brief, in the state's brief. If you have any other questions, I'll give time back.
Thank you, Council. We'll take that 37 seconds. Council, you got 5 minutes for rebuttal. You can begin when ready.
Thank you, Your Honor. Let me first address the question you left me with concerning issue 2. I am guessing that you were talking about the merits and not the way the arrow is not reserved.
I'm talking about the constitutionality of the statute.
Correct. Thank you. My challenge to that is based upon the case of Jacobson, Richardson, the United States Supreme Court at 526 U.S. 813. In that case, the Supreme Court was looking at the constitutionality of the RICO statute. And by way of analysis, and the Supreme Court, Antonin Scalia, I believe, wrote that opinion, found that jury unanimity is only reached when jurors find each and every element of a RICO statute beyond a reasonable doubt. The statute is similar in RICO that you can find, I believe, 1 or 2, I think it's 3, they have to find 3 predicate offenses. And Justice Scalia found as a rule of evidence in the Supreme Court that unanimity was required in that. I believe that that's the similar applicable provision in the state court, that jury unanimity is
So in the
required.
RICO statute, you're saying that they don't get to pick any 3 violations of RICO. They've got to agree on which 3 specific acts were the violation, were the predicate acts. By transfer then to this case, they've got to agree on specific conduct.
Correct.
And then, but that was the very conduct that I think it was Judge Cochran was encouraging the legislature to write a statute about because of the problem with these young witnesses.
That is exactly correct. And her premise was based upon the fact that it's impossible to prove the time elements typically on these cases, and which led to election issues and all sorts of other issues in like this, the standard aggravated sexual assault cases. But this statute only got a test run, I believe it was test run in California, and there was a couple of other states that adopted it. The problem with that is that the Supreme Court has never said that that's constitutional. They didn't rule on the constitutionality in Richardson. They just said as a rule of evidence, we're going to require jury unanimity on the specific elements of the RICO statute. No one has ever said, especially the Court of Criminal Appeals, that jury unanimity is not required on the specific findings that the court made on the continuous sexual assault. And I believe that in addition to that, there's several problems that deal with that, and I would ask, I would like the Court of Criminal Appeals to finally take that up after 15 or 20 years. I understand the issues concerning that, but the constitutionality cannot come second to greasing the wheels of convictions for persons who are denied due process.
And because we took that deviation, I'm gonna give you some more time to do your rebuttal on the issue.
I just have a very few issues. I want to first talk about the state's reference that this was somehow material. Propensity is not a material element of this statute. It is merely to grease the wheels so the jury can convict some more people. That's why it's offered. That's what the legislative purpose was. Second, if we're talking about error preservation, the hearing was conducted outside the presence of the jury. 103C, I believe it says that no further objections are required if a hearing is held outside of the presence of the jury, so therefore there was no waiver. This was also apparent from the record. The oft-repeated statement is, all I have to do is let the trial judge know what I want when he has a chance to do something about it. That was certainly an opportunity to basically say, look, that doesn't meet the family code, that doesn't meet the statutory definition, and therefore, we're not going to allow this juvenile conduct into the trial. And since we trotted out all of this stuff in the hearing, I think it's apparent to the trial court what was going on and what the objection was made for under the provisions that were before the court at that time. And finally, I would like to add this. When we're talking about unfair prejudice, I cannot imagine a circumstance to where there is more unfair prejudice than propensity evidence in a child sexual assault case. This isn't allowed in bank robberies. It's not allowed in hit and runs. It's not allowed in speeding. It's a punishment issue, certainly, in each of those cases. But it does not speak to the due process rights of one who is accused and tried under this case. And despite the fact, and this court, I believe, has held that 403 is applicable, period, whether or not the evidence comes in under 3837, it still has to be filtered through that statute. In order for it to be filtered through that statute, one has to consider the effect of propensity evidence and whether it can ever fall under the, get through the filter of 403 as unfair prejudice. Which each of these matters, I would ask the court to return its opinion and grant the appellant a new trial. Thank you.
Thank you, counsel. This case submitted. Counsel is excused. The court will officially stand adjourned until we meet again in November at Glen. And if there's anybody that has a question, now would be the time to raise your hand, be called on, and approach the mic, and we'll do what we can. Counsel, y'all don't need to stay at the table. You can if you.
I'd love to ask a few questions, but.
Okay, there are a couple of folks in the room that can't ask questions, and I'm sitting at council table, so. Actually, if you have a question not about this case, then, and I know that sometimes council has that may be something the students would be interested in.
Well, I would like to say a couple of words, Your Honor. For all of you may not know, Judge Gray is retiring at the end of this year. Judge Johnson, I believe, is going to assume the Chief Justice role. All have served admirably upon this court, and I thank them for their service.
Now I'm gonna call you out of order, but go ahead. Any questions? All right, well, thank y'all for hosting us. Dean McCowan, our president, doctor, all those great titles that you are entitled to. Thank you for hosting us, and we look forward to return. Okay. Second clerk into the picture.
Yes.
I don't know.
How are we? Still alive. Still alive.
Glad you could be with us. Yeah.
Glad I was able to show up.
Judge Smith, I believe I've had the pleasure before.
Thank you for allowing me to be live.
No, that's okay. glad you made it.
She's like, "Locked out," and I have a lot of my stuff.